Luigi Mangione is now facing possible execution after being federally indicted for the alleged assassination of UnitedHealthcare CEO Brian Thompson. Prosecutors claim Mangione hunted Thompson in a meticulously planned killing, but his defense claims the DOJ's death penalty push is a mere political move. I'm going to break down the charges in this indictment and why the defense is fighting back. Do they have a point that the death penalty should be thrown out? Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Well, it happened. Something we expected, something we were anticipating. 26-year-old Luigi Mangione, the Ivy League graduate from a prominent Maryland real estate family, was formally indicted Thursday on federal charges for the December 2024 assassination of UnitedHealthcare CEO Brian Thompson. And this is a case that has gripped the nation. It has reignited debates about America's healthcare system. It sparked a lot of different issues. So this indictment officially charges Mangione at the federal level with the federal crimes of murder using a firearm, interstate stalking, and firearms offenses. And the reason the murder charge is so significant is because it carries the death penalty. And by the way, that follows a directive from U.S. Attorney General Pam Bondi, which we'll talk about. But to kind of give you a little bit of background on this case, prosecutors allege that Mangione meticulously planned the December 4th killing outside of a Manhattan hotel where Thompson had just arrived for his company's annual investor conference. And prosecutors are working with some key evidence in this case, including surveillance footage apparently showing a masked gunman shooting Thompson from behind, shell casings recovered at the scene bearing handwritten Sharpie markings of the words delay, deny, depose, a 3D printed ghost gun with a suppressor believed to be the murder weapon that was recovered after Mangione's arrest, a notebook containing entries that prosecutors describe as a blueprint of violence. And one of the messages was, the target is insurance because it checks every box. And what do? You whack the CEO at the annual parasitic bean counter convention. And prosecutors believe that Mangione arrived in New York City in late November using a fake ID and stayed in a hostel under an assumed name. And they've actually matched the identification from the hostel to when he was ultimately apprehended. But I'll tell you, actually, before he was apprehended, following the shooting, he fled through Central Park on a bike, ditched it, escaped to Pennsylvania by bus, and after a 5-day nationwide manhunt, he was arrested on December 9th at a McDonald's in Altoona, Pennsylvania, over 200 miles away from the crime scene. And after being charged in both Pennsylvania and New York, so state charges, the case took a dramatic turn on April 18th when Attorney General Pam Bondi announced a federal indictment and that the DOJ is seeking the death penalty, the first such federal pursuit since President Trump's return to office. Now, Mangione's attorney, Karen Friedman-Agnifilo, slammed the decision in a motion to preclude the federal government from seeking the death penalty. And she has raised a number of different arguments. And this includes that Pam Bondi's press release, TV appearance, Instagram posts, they have unfairly prejudiced the jury. And we're going to get more into that, more into the arguments, more into emotion in a minute. But first, to help me break down everything in this indictment and the death penalty on the table, I want to bring on not just a friend of the show, not just a former New York City prosecutor and criminal defense attorney, but somebody who opened my eyes to a very interesting legal defense when it comes to the Mangione case. We've spoken to her before. We're bringing her back on, Serena Townsend. Serena, thank you so much for coming on. It's great seeing you.
Thank you so much, Jesse.
So before we even get into the charges, I just want to get your take on this part. So we have a federal grand jury, right? This panel of U.S. citizens like you and me determined that there was enough evidence in the case to move forward with charges against Mangione. We have heard so much about how much people love Mangione, support him, how he has this significant following. I mean, I think his online defense fund has surpassed $940,000, and yet he was still indicted. He was indicted in a grand jury form in the state charges in New York. I said, you know, with all this attention he's receiving, all the support, maybe they just won't indict him. Even though the standard's very low, I thought it's interesting to say he was actually indicted, no?
It is really interesting. You're right. The standard is much lower than beyond a reasonable doubt, which is what's needed to convict at a trial. the standard essentially at a grand jury level is reasonable cause to believe and legally sufficient evidence. It's basically the same level as probable cause, which is what's needed for an arrest. So it is a low level, but you're right. It does seem like there's so much support for him that it is kind of scary to see that there were enough people on that grand jury to indict him. And remember, a grand jury also does not need to be unanimous, it just has to be a vote by the majority.
Hey everybody, this is a law and crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease? And the research is potentially linking ultra-processed foods to all this? Yeah. Well, Morgan & Morgan is stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. That's a good point. And just to be clear, though, right, he is entitled to a defense. He is innocent until proven guilty. Having said that, the evidence seems pretty significant against him, and you wonder whether or not people would find him not guilty, not necessarily based on the evidence, but because they might support his cause against the health insurance industry. And I could go, on and on about the problems of that. But when you see him being indicted at a state and federal level, does it give you confidence that whatever trial we're talking about, state charges in Pennsylvania, federal charges in New York, does it give you confidence that we might eventually be able to find fair and impartial jurors?
I do. Having tried a lot of cases myself, you realize that when a jury walks in, these potential jurors walk in, they come in with a lot of preconceived notions. They come in with their own experiences, their own thoughts about a case. But you very quickly see that a judge talks to them and explains to them over and over again, no matter what your preconceived notions are, you must follow the law as I say it. And what you end up seeing is that jurors do take their jobs very, very seriously. And so it is quite possible that there will be an opportunity to find fair and impartial jurors here. They themselves may not realize it as they walk in that they can be fair. But when you hear over and over again from the judge what the instructions are and just how serious it is you have to take a case that you're deliberating about, eventually you do find that jurors will do the job.
Okay, so with that confidence in play, now let's talk about what the charges are and, whether or not the government overcharged here. I think there could be an argument to that. So let's take it one by one. I want to go through the charges. So the government is charging Mangione with 2 counts of stalking. So one is stalking via traveling in interstate commerce, and the other is via use of interstate facilities. So under count 1 via interstate commerce, the indictment alleges that from November 24th up to December 4th, Luigi Nicholas Mangione, the defendant, traveled in interstate commerce with the intent to kill, injure, harass, intimidate, and place under surveillance with the intent to kill, injure, harass, and intimidate another person, and in the course of and as a result of such travel, engaged in conduct that placed that person in reasonable fear of the death of and serious bodily injury to that person, and in the course of engaging in such conduct, caused the death of that person. To wit, Mangione traveled across state lines via an interstate bus line for the purpose of stalking and killing Brian Thompson, and while in New York, Mangione stalked and then shot and killed Thompson in the vicinity of West 54th Street and 6th Avenue in Manhattan. Serena, a lot of legalese there. I don't know
Yeah.
if you want to simplify it, but talk to me about what you make of that charge, and I believe you might have a concern with that charge because it also leads into the murder charge, which we'll get into.
That's correct. I have said it from the start when I saw the complaint, and now as I'm seeing the indictment, I do have a concern here. The simplified version of count 1 is that Luigi Mangione is alleged to have traveled interstate commerce with a bus through bus service. And in that traveling, he stalked and murdered Brian Thompson. You have to prove every single element of every single charge if you want a conviction. And so in this charge, like all the others, there is this stalking portion of the charge, which requires proof that Brian Thompson not only was stalked by Luigi Mangione, but knew that he was being stalked by Luigi Mangione because it shows in the charge that he has to have been in reasonable fear of his own death or bodily grievous bodily injury. And so I do think there is potentially a problem there, unless there's evidence that we just don't know about yet of the stalking and of Brian Thompson's state of mind.
So in other words, he has to know Mangione was stalking him. Is that what you're saying?
Yeah, that's how it reads.
Does he have to know that it was Mangione? Does he have to have just a general fear? I think I'm being stalked. I think someone's following me. And I have to wonder, I gotta say, like, why would they draft it that way, right? Why would they have to put the impetus on the victim to know that they're being stalked?
It's actually a really interesting question. And I think it goes to the reason why the stalking charge exists to begin with for any case. And that is because this charge was developed for basically for women who were being stalked in domestic violence situations. And it is a little bit weird that the victim has to know that they're being stalked in that situation, but it's not that weird because if you think about it, stalking is kind of a psychological crime, right? If you take the murder out of it, let's say somebody was just charged with stalking, the reason it's a crime is because of the position and the state of mind that you put your victim in. The stalking is not necessarily a physical injury. It is the psychological torture or warfare that you have against a person in their mind. And so if that person didn't know that they were being stalked, if you did not let them know that they were being stalked, then they couldn't um, experience the psychological torture that is required to have been stalked. And I think that's why, in a weird way, that's why it's so weird it's being used here because the purpose of a stalking charge was never really meant, in my opinion, for this type of situation. It was meant for women who were, looking behind their shoulders and being terrified of the people who were coming after them.
Right. That's fair. That's fair. Talk about stalking. You move on to count two. It is
Mhm.
stalking via use of interstate facilities. And the indictment alleges that from November 24th to December 4th, that in his intent to kill Thompson, Mangione used an electronic communication service and electronic communication system of interstate commerce and another facility of interstate and foreign commerce to engage in a course of conduct that placed that person in reasonable fear of the death and serious bodily injury to that person, and in the course of engaging in such conduct, caused the death of that person. To wit, Mangione used a cell phone, interstate wires, interstate highways, a hostel that services interstate costumes, and the internet to plan out the killing, essentially. So, Serena, putting aside the issue that we talked about before, Brian Thompson's maybe perception that he was being stalked, everything else match out? Everything else probably fit with this facts of this laid out by
Yes.
prosecutors?
I would say so because it's actually quite easy to fit into this kind of using interstate commerce or facilities when it comes to the modern day and age. As long as he used the internet or a cell phone or any sort of electrical device that crosses the path of numerous states, you fit into this category. So yes, this
Okay.
stalking charge does work. If he knew that he was being stalked.
All right, so now we go to count three. And I think that your analysis of the stalking charge is very persuasive. And it makes me wonder, was there an overcharge here with the murder charge, right, to get the death penalty? Why? Because count three of this indictment is murder, and specifically murder through the use of a firearm. And the indictment alleges that Mangione used a firearm in his possession and in furtherance of the stalking and used that gun to shoot and kill Brian Thompson. So, Serena, the only way the jury could convict him of this is if they believe he stalked Brian Thompson. And again, going to your analysis, right, they would have to believe that Brian Thompson knew he was being stalked. So if there's a problem in the stalking charge, there's a problem in the murder charge, right?
That is absolutely correct. If there's a problem in the stalking charges, they cannot convict him of murder. Yes.
Okay. Now, there is a subsection of this count with a whole list of special findings that fall under Title 18 of the United States Code, Section 3591. And it's this statute that lays out what the government needs to prove, essentially, to proceed with seeking a death sentence. So the grand jury found that Mangione intentionally killed Brian Thompson. They also found that he intentionally inflicted serious bodily injury that resulted in Thompson's death, or at least that there was probable cause to support this. And they found that he took part in this criminal act knowing or intending that it would result in Thompson being killed, and that he did this with reckless disregard for Thompson's life. Also, the grand jury considered Section 3592 of Title 18, and this has to do with any aggravating factors, meaning factors that would justify a death sentence, and found that Mangione's actions cause a grave risk of death to others in addition to Thompson, and that this was all premeditated. Now, Serena, let me ask you this, and I'm going to get into all of the objections put forward by the defense. I know why the government wants to move forward with the death penalty here. I mean, a crime like this, metropolitan city, a lot of people looking at it. You don't want copycats. There's political factors here. Do you think it makes sense that the death penalty is on the table? Just your opinion.
No, I don't. And we'll go through the actual objections that
Yeah.
the defense made, most of which I actually agree with.
Okay.
But the strongest reason why, in my opinion, it doesn't fit is because this, in my opinion, is a state level case. I do think that, like you alluded to earlier, it's overcharged just to bump it up to a federal case. And New York, as a state, does not have the death penalty. I do
Right.
think this is a state level murder in the second degree case.
Yes.
That's where it rightly sits. And if that were the case, the death penalty would not even be on the table.
I agree with you. So murder of the second degree, it's just an intentional
Mhm.
killing. That's it. And I think
Exactly.
if you look at the facts and the evidence in this case, you could make a fair argument that prosecutors would have enough to get a conviction on that. I mean, obviously he's innocent until proven guilty. He has a defense, but the first degree murder at the state level, that it's in furtherance of terrorism. We've talked about it so many times. I think that's a little wonky as well. But just sticking with the federal level for a second. So count four is the firearms offense. The indictment alleges that on December 4th, Mangione knowingly used and carried a firearm, and in furtherance of such crime, possessed a firearm which was brandished and discharged and which was equipped with a firearm silencer. Serena, any comments on that real quick?
Yeah, again, that charge also relies on the stalking charges. And so if they find that he used this gun, that it had a silencer, and that he killed Brian Thompson with that gun, even that is not enough to convict on that fourth count unless they also find that he stalked Brian Thompson.
Okay, so now I want to get into the death penalty situation here because, as I mentioned, the defense is intending to try every which way to make sure the court will not allow prosecutors to move forward with the death penalty against Luigi Mangione. And his team filed a motion essentially saying, look, the case is politically motivated. The statements from AG Pam Bondi have prejudiced the jury, and that there's no need to even try this case at the federal level because he's being prosecuted under state law in New York, where he's facing a life sentence without parole. That's the penalty if he's convicted. So I want to dissect these arguments with Serena, and then I'm going to toss it over to her. So one argument in the defense's motion is that the government's interest in this case is politically motivated. So right in the introduction of the motion, the defense writes pretty plainly, the United States government intends to kill Mr. Mangione as a political stunt. And the motion points to some examples where AG Bondi appears to tie the death penalty decision to Trump's political agenda. Exhibit A, this statement that she apparently made on April 1st at a press release, quote, after careful consideration, I have directed federal prosecutors to seek the death penalty in this case as we carry out President Trump's agenda to stop violent crime and make America safe again. And the argument here is that this frames this case as a campaign promise and doesn't really hold legal merit. Another example in here is when AG Bondi appeared on Fox News on April 6th and said, the president's directive was very clear. We are to seek the death penalty when possible. It hadn't been done in 4 years. So the argument there is that this decision was driven by an executive directive rather than DOJ protocol, and that this decision is arbitrary. Serena, your thoughts?
Yeah, I mean, the truth of the matter is we had another recent indictment dismissed with prejudice, that of our mayor, Eric Adams, because of extrajudicial prejudicial statements where Eric Adams argued that those statements made by the US attorney tainted the potential jury pool in his case. And so it's hard to imagine that with Pam Bondi making extrajudicial statements like this and opening up a new Instagram account with this as her debut kind of post, and citing that this is Trump's way of making America safe again, and saying all of these things publicly, and not also balancing those statements with, by the way, he is innocent until proven guilty. These are just allegations at this point. She doesn't do any of that. That definitely, I think that argument holds merit. I think that they could have prejudiced either both the grand jury and the trial jury, or really just anybody who could potentially serve here on this case with those statements.
Well,
So, you know,
let me ask you, let
yes.
me press you a little bit on that. When you say extrajudicial
Okay.
statements, you mean out of court statements, just so everybody
Yes.
knows what we're talking about. Isn't every decision a little bit political, right, in terms of a death penalty? I mean, you could make the argument that when prosecutors move forward with the death penalty, there's a lot of considerations. And what do we mean by political? Is it to help someone, their campaign? Is it so they're, because a lot of them, you're dealing with situations where people are going to be reelected or things of that nature. So it just makes me wonder, couldn't you make that argument always? And as long as the law is on your side, as long as you have aggravating factors that are supported by the law, and you heard the grand jury voted in favor of it, is that a stretch?
I think that this argument of theirs is probably their weakest. You have a point. I mean, I think they have better arguments in their motion aside from this one. And I think you're right. Also, anytime you have a new political leader, they have their own agenda. Agenda being used in like literally the literal sense of the word agenda, not necessarily in a nefarious way. So you're right on that front. But I do think that we need to take extra precautions when you have somebody's life on the line. It's one thing to say, we have an agenda here to cut down on this type of crime over that type of crime, and therefore we're going to be prosecuting more drug dealers than we have in the past. That kind of thing I could understand. It's a mission, it's the way that they want to lead the country. But I do think that once it crosses the line to actually putting somebody to death, we have to tread very carefully when we make those decisions. I think that's really where I see the distinction here.
Okay. And by the way, going along with Bondi's public statements, another argument from the defense is that her public statements have essentially poisoned the jury pool, because she, for one, plainly stated that Mangione was guilty. For instance, the defense points to what she posted on her Instagram, arguing the inaugural two posts of the Attorney General's new Instagram account were a photograph of the Attorney General standing before the seal of the United States Department of Justice and the following message: Luigi Mangione's murder of Brian Thompson, an innocent man and father of two young children, was a premeditated, cold-blooded assassination that shocked America. After careful consideration, I've directed federal prosecutors to seek the death penalty in this case as we carry out President Trump's agenda to stop violent crime and make America safe again. So two problems with this. The defense says, one, this language frames Mangione as already guilty to a jury that has to evaluate evidence impartially. And two, it reiterates the political framework behind the decision. Now, I get the argument here, Serena, but again, if he really did commit this crime, she's not wrong to say that it was a cold-blooded, premeditated crime, and that obviously prosecutors believe he committed the crime. Sure, that's why they're moving forward. Even when there's press conferences, they say the evidence would support that he did this, right? Or a defendant commits a crime. What is she doing that's so irregular?
I think that when you're in a position of power like that, you do have an obligation to balance your message. You do have an obligation to remind the public that charges are merely that until he's proven guilty. If you see in the past, I'm sure you've seen it a thousand times when a U.S. attorney's office, for example, puts out a press release about an indictment, they will always include something at the bottom that says, as a reminder, an indictment is not a conviction. An indictment is merely an accusation. There's at least some softening, I guess, of the
Sure.
language. And so you just want to tread carefully when you're in that position of power so that you utilize your position in the right way without crossing the line.
Rather than authorizing the SDNY prosecutors to seek the death penalty in a non-public communication, the Attorney General saw fit to direct them to do so via press release. In this release, she did not once say that Mr. Mangione had not yet been indicted for any federal crime or that these are mere allegations. She never once discussed the presumption of innocence or that Mr. Mangione is innocent until proven guilty. Now, one of the central arguments in this motion is that prosecuting Luigi Mangione at the federal level, especially as a capital case, it disregards the traditional federal-state balance in criminal prosecutions. The defense points out that Mangione was already indicted by the Manhattan District Attorney's Office on a first-degree murder charge and other charges, too, before the federal complaint was filed, and that the prosecution at the state level is still effective. The motion reads, the state's case charges, among other crimes, the crime of murder in the first degree in violation of Penal Law Section 125.27. This is the single most serious offense recognized in the New York penal law. As the Justice Manual also makes clear, the fact that the state of New York does not currently have a death penalty does not make the state's prosecution of Mr. Mangione any less effective. Indeed, the manual seems to have contemplated this exact situation and provides that a state prosecution can be altogether effective even if it cannot legally result in capital punishment. In other words, just because New York can't seek the death penalty doesn't mean federal prosecutors should automatically step in. And the defense lays out what is inscribed in the Justice Manual when it comes to taking on cases. It reads, prior to charging a capital offense, prosecutors must carefully assess whether an accused is subject to effective prosecution in another jurisdiction and thoroughly review the substantial federal interest principles. Priority should be given to crimes causing the most harm to the nation, including through widespread impact to the community. Serena, what do you think?
I think it's actually a very effective argument. I think the fact that the state case is already in the process of moving forward, was already indicted, has already kind of developed, discovery has been exchanged. It's a very strong statement and a strong argument, in my opinion, for the defense to say, listen, your own manual, the Justice Manual, tells you that before you engage in a federal prosecution, you have to consider whether Luigi Mangione is going to be effectively prosecuted already. Meaning, let's prevent a pile-on. Why are we bringing in federal charges when he can effectively be punished, at a state level? And they're right. There is case law supporting the argument that even if the state level doesn't have the ability to legally seek the death penalty or has not had the policy of seeking the death penalty, that doesn't negate the kind of decision that it's an effective prosecution anyway. It could still be an effective prosecution, even if the death penalty is not on the table on the state level. I actually think it's a compelling argument for them to say, why are the feds coming in to prosecute somebody who's already being prosecuted at the state level? And as you and I talked about earlier, I do think that this fits the state level prosecution way better than a federal prosecution anyway.
Okay, well, let me get your opinion on the last argument. So the last argument
Mhm.
here is where the defense says that Luigi's case is an outlier from some of the other cases that have been tried at the federal level. So the motion argues that since 1988, the U.S. Attorney General has filed a notice to seek the death penalty in just 17 cases, but that all of those cases show a specific pattern. The motion reads, every one of the cases involved defendants who committed murder as part of a violent drug or racketeering enterprise in furtherance of a narcotics business or as part of a terrorist organization. This alone is a major distinction from this case. A defendant who has joined a violent drug racketeering or terrorist enterprise has already made a commitment to significant criminal activity. This is obviously not the case with Mr. Mangione. Let me continue. The defense argues that out of those 17 cases, 4 of them involved one murder, but with extreme elements to it. For instance, the case of Derek Frank, who murdered a witness after kidnapping and torturing him. The defense also names Jose Santiago, who ordered a murder in front of the victim's wife and children. Alan Quiones, Diego Rodriguez, they apparently carried out a contract killing of an informant as part of a violent drug gang. And the defense argues these 4 defendants are vastly different from Mr. Mangione for a host of reasons, only some of which we will note here. First, each of the 4 defendants charged with one murder was involved in serious criminal activity, whether that be dealing in narcotics or being a member of a violent drug or racketeering enterprise. Second, all of the defendants committed murder involving torture or physical abuse of the victim, which is not present here. Third, 2 others committed a contract killing of an informant. Of course, for the remaining 12 defendants, each committed multiple murders and did so as part of a violent drug enterprise or terrorist organization. While the Attorney General stated during her television appearance that if there was ever a death case, this is one, that statement is wholly inconsistent with the historical record of death penalty cases in this district. Now, Serena, all these cases are terrible. What happened to Brian Thompson is terrible, and I would imagine that his family would feel the same loss and pain and say that this is just as egregious and terrible a crime about what happened to Brian Thompson as it happened to the people who were murdered in these other cases. But from a legal point of view, do they have a point that this shouldn't be one of those cases? Although, remember, the state prosecutors are saying this was a form of terrorism.
Yeah, it's a very good point. First of all, I want to say that this argument is so strong and is so good simply because it doesn't stand on its own. I think the motion that the defense wrote is brilliant because each point that they make kind of builds on each other. The fact that they're treating Luigi Mangione differently than the norm, I think is kind of the common thread throughout the defense argument, right? That Pam Bondi is making extrajudicial statements and she's advising publicly, which is different from the norm. That they're going forward with this case despite the fact that the state already has a case pending that could effectively prosecute him is going against the norm. And here you have the kind of comparison between his case and the other 17 cases in the last 40 years that the feds have sought the death penalty, and they're saying it is different. Of course, if you are Brian Thompson's family, you're not looking at this as any less painful, and that is completely understandable. But they're tying in those 17 cases with the aggravating factors that they mentioned earlier in their motion, saying that Luigi's aggravating factors pale in comparison to the ones where the death penalty was actually sought. I think the defense argues that the only real aggravating factor that you can argue to bump him up to the death penalty is the substantial planning of the killing. And one could argue that that in and of itself is not really the most aggravating factor when you look at other aggravating factors like serious prior criminal history, the the heinous and grievous way that the thing was carried out. I think some of the other death penalty cases involved killing in front of children or sexually abusing children. And so those are usually the bump ups that happen in a death penalty case. And the last thing I'll say to that is sadly and unfortunately, we have seen many murders in New York and in the country, many murders that require substantial planning and premeditation, and they're not being punished on the federal level. We see it with gang activity, we see it in domestic violence, we see it all the time, and yet Luigi is being prosecuted as a death penalty candidate and none of these other murders are. So I do think there is a distinction there that needs to be looked at. And I think the defense makes a valid argument.
Mangione remains detained in a federal jail out in Brooklyn. If convicted on state charges alone, he could face life in prison. He's due in federal court for his arraignment on April 25th. Serena Townsend, so great seeing you. Thank you so much for jumping back on this case to talk about it.
Thanks, Jesse. It's always a pleasure.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.